Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA or Latin America to learn how to manage your IP assets and expand your business successfully.
Welcome everyone. Thank you for joining us for today's webinar on the legal impact of AI-generated content on intellectual property in collaboration with EuroCham Malaysia and Southeast Asia IP SME Helpdesk. I am Padmaloshni representing EuroCham Malaysia, and I will be your MC for today. This would be the agenda for our webinar today. We have a brief session covering the definition of AI-generated content, legal interpretation of ownership and inventorship under the Patents Act 1983, and a discussion on the recent UK decision of Stephen Thaler's DABUS patent, presented by Ms. Suriyia Sadanathan, followed by Mr. Muhammad Azrul Abdul Hamid's insight on IP rights and potential infringements in relation to AI in Malaysia. And at the end of the session, we will be having a Q&A and a conclusion for our event today. To start our event, I would like to be honored to invite Mr. Martin Schlotelburg, Counsellor and EUIPO IP Attache for Southeast Asia, Delegation of European Union to Thailand, to deliver his opening remarks. The floor is yours, Mr. Martin.
Thank you very much, Fatma, for the kind words. Dear ladies and gentlemen, I am honored and pleased to deliver the opening remarks for today's webinar on AI and IP on behalf of the Director General for Trade of the European Commission. Artificial intelligence, AI, is a fast evolving family of technologies that can bring a wide array of economic and social benefits across an entire spectrum of industries and social activities. It has the potential to provide competitive advantages to those who know how to master it. However, the same elements and techniques that power these benefits may also bring new risks and undesired consequences. In light of these challenges, the European Union is committed to strive for a balanced approach. The seminar of today addresses the intersection between AI and IP, intellectual property, which is one of the areas of risk, notably through the development of generative AI and its impact on copyright. In this context, please allow me to briefly explain the current state of play of the legislation of the European Union. As you may know, the European Union Copyright Directive of 2019 introduced a text and data mining exception, TDM exception, which allows right holders to opt out from TDM activities, including situations when they are carried out for AI training. Opting out allows the right holders to license their contents and receive remuneration for the use of the work in AI training. The European Union considers the opt-out clause an important balancing element to safeguard the interests of right holders. In December last year, the European Union co-legislators reached a political agreement on new regulation harmonizing the rules on AI. It's the so-called AI Act. You may hear about it certainly later on. This AI Act transposes European values to the new area. It is focused on regulating identifiable risk, thereby fostering responsible innovation in Europe. It guarantees the safety and fundamental rights of people and business and supports the development, deployment, and take-up of trustworthy AI in the European Union. The EU approach is based on a risk analysis, distinguishing between minimal, high, and unacceptable risk. AI systems considered to be a clear threat to fundamental rights fall in the category of unacceptable risk, with the consequence that they will be banned. The Act also foresees the imposition of fines in case of non-compliance with the rules. Mitigating risk to fundamental rights is among the primary rationales of the EU AI Act. These fundamental rights explicitly include intellectual property rights. Specific attention is paid to generative AI systems as they raise critical questions related to the generation of content in breach of union law, copyright rules, and potential misuse. Generative AI systems are known to be capable of creating text, images, audio, and video with the help of so-called foundation models, which are trained on vast amount of work scrapped from the internet and often subject to copyright. In order to deal with some of the identified risks, the AI Act contains specific provisions related to copyright. Generative AI developers need to respect EU copyright rules, including the right to opt out from TDM exception. And they need to be transparent with regard to the contents that has been used in training the AI, providing said information in sufficiently detailed manner. It is important to note that the final text of the EU AI Act has not yet been published and still needs to be approved on a legal level. It is likely to be published in the first quarter of 2024, different provisions of the AI Act, however, will become applicable at different moments within 2 years after its entry into force. To bridge the transitional period between the AI Act becomes applicable, the Commission will launch a so-called AI Pact, convening AI developers from the European Union and around the world to commit on voluntary basis to the implementation of key obligations of the Act ahead of the legal deadlines. With regard to the output generated by the AI, there are no rules set at the EU level, but some case law is already emerging in the member states of the Union, notably how to draw a line between a work created by the use of AI that still can be considered to be an original creation by a human, in contrast to work where it is not. We can see already these questions arising across the world, and we will possibly face diverging answers. In order to strive for a harmonized approach and to promote rules on trustworthy AI, the European Union will continue to work on international level in fora such as the G7, the OECD, the Council of Europe, the G20, and the United Nations, and we will continue monitoring and discussing internally the latest development. The webinar of today is one of the means the European Union is looking at to support our engagement for a human-centric, transparent, and responsible development of AI. The European Union, we would like to thank the EuroCham, Malaysia, and the SME IPR Helpdesk for organizing the event of today. And I wish the participants and all of us a fruitful day. Thank you very much.
Thank you, Mr. Martin, for your insightful opening remarks. Now, I would like to pass the floor to our honorable guest and moderator for today's session. The moderator is Mr. Chew Fee Kit, Head of Sector Committee on Intellectual Property Rights at EuroCham Malaysia. Mr. Fee Kit is a highly experienced professional in corporate, commercial, ICT information and communication technology, and intellectual property laws. He has extensive experience in managing various corporate and commercial transactions across a wide range of industry. The floor is yours, moderator and speaker.
Thank you, Roshani, and welcome everyone to our very exciting AI seminar or webinar, and with our two esteemed speakers who will guide us through issues. Before we proceed, a quick housekeeping note. If you have any questions along the way as you hear the speakers, or in your own mind you've been wondering about some of these issues, please feel free to type in your questions in the question box that you see at the bottom of your screen. And I can't promise we can deal with every question, but we'll definitely consider all of them and see what could be useful for the webinar later in the meeting. So I'd like to welcome our first presenter for today. We're very happy and honored to have with us Ms. Suriyia Sadanathan from Adastra IP's Berhad, who will be covering quite a handful of topics: the definition of what's an AI-generated content, the legal meaning or interpretation of ownership and inventorship under Patents Act and how it applies to the AI world, and of course, the much publicized and debated decision of Stephen Thaler's DABUS patent. Ms. Suriyia is a registered patent and industrial design agent with degrees in computer and communication systems and law, having worked for 4 years as an engineer with Motorola R&D department before commencing her IP career. She has had 15 years of experience so far, and still counting, as a patent professional, with knowledge in both Malaysian and international patent drafting, filing, and prosecution, in addition to assisting clients in matters relating to IP and, of course, patent strategy. So I hand the floor over to Ms. Suriyia to give her presentation. Thank you very much.
Thank you, Mr. Chew. Good afternoon, everyone. Yeah, my name is Suriyia and I'm from Adastra IB. So I'm here today to bring you through and to navigate you through the topic of basically intersection of technology and IP law, specifically on artificial intelligence. So as you could see on the slide, so basically what's the definition of artificial intelligence? So artificial intelligence, as we know, in its simplest form, it's actually a machine. AI is a machine that exhibits human-like intelligence. It encompasses computational systems whereby it provides behavior commonly perceived, such as learning, evolving, reasoning, inferring, making decisions. So similar to humans, AI relies on experience. AI relies a lot on experience based on previously fed data sets to autonomously address complex issues. So complex issues which mimics human, where the machine is trained to actually perform such behavior. So AI would analyze and okay, sorry, I was told that there's a technical issue. Yeah, so sorry, can you see my screen now?
Yes.
Okay, thanks. Sorry. Okay, we'll start again. So yeah, good afternoon, everyone. Yeah, I'm Suriyia from Adastra IP. Yeah, so basically I'm here today to share with you on to navigate you through the intersection of technology, basically artificial intelligence and IP law. Yeah, so in its simplest form, AI is actually a machine tool. It's a tool that exhibits human-like intelligence. So what do we mean by human-like intelligence? So human-like intelligence basically is something, a machine that actually mimics human behavior, whereby it evolves, it reasons, it infers, it makes decisions basically on very practical terms of what we do on a daily means. So AI relies a lot on experience. That's why it's actually a data set that's trained. So this data are actually fed data sets. So it's actually related to machine learning to actually autonomously address complex issues. So in short, AI relates to machine learning and it's actually categorized as computer implemented inventions. So AI systems gain insights, adapt, and enhance their problem-solving abilities. Yeah. So overview of AI-generated content. So AI, as I mentioned, coupled with machine learning algorithms, are actually human-like creative skills. So we know that recently, I mean, AI is a cutting-edge technology, being the most recent technology that we see today. So recent AI developments enable machines to actually independently perform creative tasks. So it assists in multiple complex functions, such as developing inventions, device inventions, automation, creative process flow diagrams, and AI has now ventured into multiple areas, including musical, literary works, visual artwork, apart from technical, pure technology, which involves technical means. So AI-generated contents refer to creative works that's produced through the assistance of machines, these trained machines, which involves algorithm, regardless of whether it's with or without direct human involvement. So there would be a case that we could actually discuss further, which is the Stephen Thaler's case, where it involves a machine, a tool, which I will discuss further after this slide. So examples of AI-generated content. So as I mentioned, it involves inventions, which are technology per se. So inventions were innovations which leads to creative inventions in all areas of technology, from engineering, all areas of engineering, healthcare, which involves life sciences as well. Yeah. So, and text which would be, for example, ChatGPT, OpenAI. So these are the AI algorithms which generate contextual relevant text based on prompts, prompt commands to enable you to automate a particular command for a particular usage. So apart from that, AI is also seen in the area of art and music. And when we say art and music, this would be more to copyright, where, for example, look at Google Magenta. It demonstrates the capability to compose original music. So it creates visual art as well. So it's very evolved. I mean, as of today, I mean, it is a cutting edge technology and it's very evolved, where it evolves from inventions, text, art, and music. So these are examples of AI generated content. So, okay, I mean, we have been speaking about AI being a cutting edge technology where it's very evolved in the world today, but there are various challenges which we see with AI generated content. And what are the challenges that we face today? So basically, the main challenge would be ownership, proprietary issues which arise. Whether would AI be considered as an inventor? I mean, would AI contribute significant to inventive process? Because as we know, or as I mentioned earlier, AI encompass computational systems which are machine trained, revolving data set that is kept in the system that is trained autonomously to perform a particular task. So with this rapid evolution of AI technology, I mean, how would we see these issues in terms of proprietary rights? So the lack of adequate regulations and standards may hinder the effective protection of AI-generated content, where we would actually look at the provisions that statutorily provided in the Patents Act later. So similarly, I mean, we could also identify instances of copyright or patent infringement involving AI-generated content, as it would be challenging to determine the ownership if AI, the machine, the tool, is accepted and considered as an inventor. Yeah, and also the issue as to how would the applicant derive the rights from the inventor, who is AI-based, who's a machine, as well as AI being an inventor, if it's accepted, in assigning the rights to the applicant, who's the owner. So those are issues as in proprietary issues which may arise. So in that regards, I mean, we need to look at a possible solution in order for us to achieve harmony in IPR laws, I mean, related to AI-generated content in general, which I would say that is a complex task as of now because it's a debatable issue. Moving on to the next slide. Okay, so who is the inventor or owner of the patent? So we know that inventor is a natural person, a legal person that devised the invention. So the role of the inventor in an invention. So the inventor basically initiates, conceives, develops, devises a particular invention that's patentable, and of course patentable based on the patent requirements, as compared to ownership. So ownership is the owner that has the rightful owner, the rights to the invention in terms of exploiting the invention, exploiting the patented invention. So that's the clear difference, a line that's drawn. Unless the inventor is the applicant, then that's an overlap. So otherwise, it's a clear distinction between the inventor and the owner. Yeah, so ownership option, of course, as I mentioned, the inventor can also be the owner. Otherwise, the owner could be a corporation, a body, a legal entity. So the rights of assignment. So the rights of assignment is where inventor would assign the rights to the applicant who holds the ownership, and the owner has the authority over the invention to exploit the invention, to take action on pending application and enforce its rights. Yeah. So decision-making authority falls between the inventor and the owner, whereby inventor has the primary say before the invention is patented, together with the owner. But in terms of enforcing the patent rights, that goes to the owner being the rightful person to exploit the invention. So these are just basic terminology to explain the differences between being an inventor or an owner, in order for us to discuss further as to whether AI would be considered as an inventor, for AI being a machine or a tool in general, which is mechanically trained. Yeah. Yeah. So back to the question. So can AI be an inventor? Yeah. So is it possible for AI to assume the role of an inventor? Because as far as we are concerned, I mean, for patents or any other IP rights, I mean, being available throughout, now we know that AI has to be a natural person. It has to be a legal person. So AI being a machine, being a tool, is it possible? Can it be an inventor? So the question is highly debatable. I mean, it is still debatable actually, because patent laws in many jurisdictions do not currently address this specific aspect. I mean, there is no such thing as, there's no phrase as of now that says that, okay, an inventor which is AI assisted, because as far as we know, inventor is a natural person. So we have to look at the decisions of several jurisdictions around the world as to how is this being decided. So for example, I mean, the case that we are going to discuss today is the case of Thaler, where he actually, Thaler's patent application. So there are two applications in general that he has filed. One relates to the food container and the other on the rescue beacon. So the inventor, I mean, Thaler claims that the inventor is DABUS. DABUS is the machine, the tool, the AI agent that created the invention. So Thaler's case, I mean, it was actually objected before the patent office, and from the patent office he appealed the matter. It went up to the Supreme Court actually. So the decision, the last decision of the Supreme Court was decided. The judgment was given just very recently, December 2023. So December 2023, and the primary contention that was presented by Dr. Thaler is that he's of the view that inventorship extends beyond natural individuals. So, I mean, during the entire patent suit, during the trial, I mean, of course, he submits his arguments and the grounds as to why he was of the view that it extends beyond natural individual, and DABUS, the machine, should be named as an inventor. So, in view of his arguments and the entire evidence that he has provided, the court, which is the highest level court, the Supreme Court, decided that the Court of Appeal did not err in their decision, where his applications were withdrawn, and the legal person, the inventor, should not extend beyond any natural individuals. I mean, it has to be a natural person and a legal person. So similarly, I mean, I've also studied the situation in other jurisdictions, namely EP, US, Australia, China. So in these 4 other jurisdictions, like what we could see on the slide, position of EUIPO. So EP, UK, DABUS being a machine, it's ineligible for consideration as an inventor. I mean, in accordance to the patent statute, where a natural person only qualifies as an inventor. So I mean, this is an established principle that it states that only a legal person, a natural person can possess IP rights. So before we go on to the relevant sections and regulations provided for inventorship under the Malaysian Patents Act as an example for purposes of our discussion today, I've mentioned that I've studied the scenario in various jurisdictions, namely EP, US, Australia, and China. So just to share a bit, so EP, it follows the EPO guidelines, EPO law, where inventor has to be a natural person. So similarly, US takes the same standpoint as well, where it has to be a natural person. So Thaler's application was rejected in US as well, that it did not list DABUS cannot be listed as an inventor. It has to be a human. So the situation in Australia is slightly different though. So the situation in Australia is that it was initially favorable. I mean, initially it was taken that DABUS could be named as an inventor, but thereafter it was decided that there's a further appeal that was filed to the federal court, where the federal court actually squashed the judgment on the basis that application does not comply with the statute. So similarly, China has also decided against AI, where the machine cannot be named as an inventor. So majority of the jurisdictions actually decided that the machine, the tool, could not be named as an inventor. It has to be a legal person. However, there are 2 other jurisdictions, which is Singapore and South Africa, which provides a favorable. Singapore has got a neutral view though, because Singapore has recently launched what we call a national AI strategy. So they do not have much of a comment, but they have raised their concerns as well as to whether the machine, a tool, could in future be named as a natural, could be named as an inventor, could be regarded or has similarities as to inventorship, but they have raised their concerns. As to South Africa, it has got a totally different outcome, which I will discuss later. So now let's look at the relevant sections and regulations regarding inventorship under Malaysia's Patents Act. So as statutorily provided, similar with other jurisdictions, we could see that there are provisions which defines invention, where invention is an idea of an inventor, and there are also regulations in the Act that states that it requires, a patent application requires the name and address of the inventor and the manner as to how the applicant derived the rights from the inventor. So in terms of, with this regards, we could say that when name and address of the inventor is required, where patentable invention belongs to the inventor and the manner as to how the applicant derived the rights. I mean, it is clear that AI, the machine, could not or should not be named as an inventor. It has to be a legal person. Yeah, so that's the legal interpretation of the Act, where AI cannot be an inventor. So yeah, this was what I mentioned just now. Apart from the 4 jurisdictions, apart from EP, US, Australia, and China, South Africa decided differently though. South Africa actually named DABUS as an inventor. But again, although South Africa named DABUS as an inventor, I mean, in general, South Africa is not an examining country where patents are not substantially examined. So granted patents in South Africa faces opposition and a high volume of invalidation by third parties. Yeah, but of course, I mean, patents that's granted, it's valid and subsisting until an opposition or invalidation occurs. But it's just to share with everyone that that's the scenario now, I mean, in the world, where majority of the jurisdictions regard AI as not, I mean, it's disregarded as an inventor. Inventor remains as a natural person and a legal person. Yeah, so this was Australia. This is Australia, which I mentioned just now. Yeah, so AI is not expressly excluded as an inventor primarily, but the Australian Federal Court then decided against that, where it remains the same, the decision remains the same as the other jurisdiction, where AI, DABUS cannot be named as an inventor. I mean, it was initially recognized, but then it was later on, the judgment was squashed. Yeah, so AI as inventor in other jurisdiction, and arguments in favor of granting protection of AI-generated content. So what's the arguments? I mean, arguments in favor of granting. So what does the patent office, what's the take of the patent office? I mean, are we supposed to, patent office, will they grant AI inventions? Apart from AI, the topic of AI being an inventor or regarded as an inventor. So basically protecting AI-generated content aligns with economic interest as it encourages innovation and investment, because AI, I mean, it's a very useful tool. So it is definitely a useful tool where it's a machine, it's a computer implemented invention where it's assisted by human, I mean, the context. So AI should be granted protection, I mean, as a generated content, but however, AI should not be named as an inventor. Yeah, so AI coupled with human interaction, where there's a programmer, there's an owner, there's a user. So it then can be regarded as a proxy author, proxy inventor. So the human would be regarded as the inventor. The invention is devised by the inventor, the human inventor, but being mechanically trained, machine trained through machine learning languages, coupled with the mechanism, the automated mechanism that makes it AI, that assists the technology in terms of innovation with a huge level of economic interest. So it is in favor of granting this protection. And also statistically, I mean, if we look at EPO statistics today, I mean, the number of applications that's filed that's actually AI related, I mean, it's grown way tremendously compared to perhaps 10 years ago. So there are like a huge number of inventions that's actually AI based in all areas of technology, be it engineering as well as life sciences. Yeah. So basically in terms of IP, both patents and copyrights, I mean, it revolves around human creators, and there are challenges in terms of AI, but how are we going to cope with these challenges as to differentiate between the rights of the inventorship? So it's still a very debatable topic as of today. Yeah. So, well, in conclusion, I mean, from what we gathered today, as well as the decisions made by multiple jurisdictions, which is favorable to the legal person, natural person, being an inventor, what I would say is that patent protection extended to AI generated content, it is a necessity. It's definitely a necessity in view of its robustness, in view of its creativeness, in view of the cutting edge technology. But perhaps there could be amendments to IP laws to incorporate and recognize AI generated content. So perhaps in terms of inventorship, so perhaps there could be two forms of inventorship. I mean, the natural person being the inventor, and when it comes to AI forming the technology, we could perhaps have like inventor, AI assisted inventor. I mean, that's for discussion purposes in view of this area where it's currently being debatable across multiple jurisdictions, where you could see that the major jurisdictions, of course, it's favorable towards the legal person being the inventor. As I said, okay, South Africa, the DABUS was granted in South Africa, and of course, the negative side is that in South Africa, it's not substantially examined. But again, like Singapore that launches a national AI strategy, I mean, okay, they have not stated their opinion, but they've raised their concerns. So it's still debatable as of today. But AI generated content, I mean, it encourages a lot of social benefits. I mean, it assists us in terms of technology, in terms of various areas of our life today. So it should be provided protection in general. So in terms of inventorship, there could be amendments in future. It's an area to be discussed, whether to include inventorship with AI assistance as part of the provision in the statute. Yeah. So thank you very much. Thank you for listening.
Thank you very much, Suriyia. It's a really tough area. If this was a football match, at the moment, either we say, is it 1-0 or 6-0? Because the courts have decided at the moment that when they read the legislation currently in their country, an inventor is not, must be human or natural or legal person. Yeah, so at the moment, I guess the ball is already left the court and it's now in the legislative, right? And whether the legislature wants to change the law to allow it, yeah, since the courts are viewed in the other direction. So that's about ownership and inventorship, lots of issues surrounding that. We move on now to the topic of infringement, right? And this is the other issue, right? Can you get the cake and eat it, right? I can own the patent even though it's the AI that gave it to me, right? But then when the AI causes an infringement, do you then say, I didn't infringe it, it was the AI that caused the infringement and I shouldn't be held liable, although I was the one that prompted the AI to generate that output. So for this, we move to our next presenter, Muhammad Azrul Abdul Hamid, a partner from the law firm of Azrul, Liew and Co., to give its insights on IP rights and potential infringements in relation to AI in Malaysia. Azrul is a member of the EuroCham IP committee and serves as an IP external expert for the Southeast Asia IP SME Helpdesk. Additionally, he is a member of the Cyber Law Committee of the Malaysian Bar. Azrul achieved a notable ranking in Band 3 of the Chambers and Partners 2020 and 2022 publications, where he was acknowledged for his well-recognized expertise in IP practice, particularly in enforcement matters. Over to you, Azrul.
Thank you, Mr. Chew, for your very kind words. So I think what we're going to see today is a common theme as to whether the laws recognize AI as a qualified person or not. But briefly before I start, I just like to do a bit of plugging for this Southeast Asia IP SME Helpdesk. The Southeast Asia IP SME Helpdesk is the first line IP assistant for SMEs from the EU and the other single market program countries that operate in or intend to access the Southeast Asian market and that want to improve their global competitiveness. So if you are an SME from the EU and you are thinking of coming over to the Southeast Asian market, this is a very good platform for you to stop by before you come over to Southeast Asia to look at how you can prepare yourself to perhaps what kind of legal expectations you can have when you want to enter the Southeast Asian market. The EU SME Helpdesk is also available in places like China, the Middle East, around the world. So it supports small and medium-sized enterprises from the EU and other countries of the Single Market Program to both protect and enforce their intellectual property rights in or relating to Southeast Asian countries through the provision of free information and services. So if you go to their website, there is a lot of information about the different countries in the Southeast Asian region with regard to IP rights. And you also have free access to their external experts if you email them at expert@ciphelpdesk.eu. There will be somebody attending to your queries. Okay. So you can, we have a lot of events, we have publications, and you can see that from our website. We conduct webinars or workshops such as this. We also send out newsletters to our clients. So the agenda for me today is to just give you an overview of the IPR rights in Malaysia, how that affects or whether AI is something that is covered in the legislation in Malaysia, and what next for Malaysia in relation to AI. Okay, Malaysia, we have all the general or usual legislation when it comes to intellectual property. We abide with the Paris Convention. We actually have all the rights protection for IP in Malaysia. We have a legislation for trademark rights, copyright, patent, industrial design, and of course, with being a common law country, we also have common law rights in relation to confidential information or trade secrets, and we also have a Personal Data Protection Act. So I'm just going to give a brief overview of this legislation in Malaysia. I mean, I think all of you probably know about all these rights already, but just to briefly look at it now so that we can have a point of a standpoint when we want to look at this vis-a-vis how AI can be governed by legislation in Malaysia. But I'm going to give you a spoiler. The answer is going to be the same as what my colleague has indicated earlier. We require legislation to keep up with what is the current trend when it comes to technology in Malaysia. And at the moment, there is nothing that really deals with AI in Malaysia. Okay, we go to trademarks. So everybody knows what a trademark is. A trademark is basically a brand. We had repealed the old act. We have a fairly new act, not so long ago, where now we call a trademark a sign. And a trademark now can encompass a lot of things, not just a name or a logo. We can now also register a trademark for colors, for sounds, for scents, hologram, and also a sequence of motion. These are some of the non-traditional marks that we also have now in our legislation. So how do you register? If you are an owner of a trademark, you make an application to the Malaysian Intellectual Property Corporation. You have to log into their account and you can do it online. Or if you want more an easier way to do it, you can also hire a lawyer or trademark agent to do it for you. And in Malaysia, a trademark is not only protected by legislation. In Malaysia, a trademark is also protected by common law rights, where you have, if you can show that you have a right over a particular trademark, you can claim rights over that trademark pursuant to your common law rights. Okay, so what is the trademark system in Malaysia? So in this, in the world, there is two types of rights that you have. First to file, which is something that is the general rule in China. But in Malaysia, because we use the common law, it is first to use a trademark. So for example, if you have a right, you have been using a mark for many, many years, you have not registered that mark, and you find that somebody else has filed an application for that mark, you may claim rights over that trademark, over that over that person who has tried to make an application for your trademark. But you must remember that in the Trademarks Act, there is also a provision that states that if you have registered your trademark for more than 5 years, it is conclusive evidence that you are the proprietor of that trademark. So you must be aware about the use of your trademark and also the use of your trademark by other people when you are in trade in Malaysia, because you don't want to be in a position. I have a few cases that I am looking at recently where the client has been using is the first user of the mark in Malaysia, and they have found that there is another registered mark in Malaysia, and that mark has been registered for more than 5 years in Malaysia. And we are trying to figure out what kind of effective enforcement action we can take against this person who has already registered that trademark. I mean, the law says you can expunge that mark if you can show fraud, etc. So it is going to be an uphill task for cases where you do not take immediate action to protect yourself against people who are using your trademark in Malaysia. So Malaysia adopts a first-to-use system. If you first to use the trademark, you have the first rights over the trademark. First use defeats first application. So that's the phrase that you usually use. And the benefits of a trademark registration, like I said, is prima facie evidence of ownership. You get a certificate for your trademark registration. You get protection. You get trademark protection every 10 years. You have to renew your trademark application every 10 years. If you don't renew it, it may be deemed to be abandoned. For purposes of enforcement, it's cheaper to enforce your rights if you have a registered trademark, and you can stop, in essentially, other people from using your trademark in Malaysia. Okay, so I think when it comes to AI, the more pertinent legislation, I would say, is the Copyright Act, and of course later the Data Protection Act. I mean, you may already know that copyright is in relation to things that is produced. It's not a trademark, you know, it's not a brand. Copyright are things that you have put in sufficient skill and effort. It does not protect ideas. It arises automatically when your effort is original. It is in material form. What that means is that it has to be in the form of a book or a CD, and the author is a qualified person. So this idea of who is this qualified person is going to be the pertinent question when we ask whether an AI can be an author of a literary work, for example, or a photograph. And in Malaysia, we are a member of the Berne Convention. So a qualified person does not just have to be a Malaysian citizen. It can also be a citizen of any of the countries within the Berne Convention. Okay. So who owns it? The general rule is the author is the first owner. But if the author is not always the owner, it can be a person who has commissioned you to be the owner of the copyright as well. Okay, so for example, if you work with somebody and your employer asks you to do something, and you come up with a work that can be copyrighted, you do not own that work. It is owned by your employer. I mean, a good example is like the coders for software companies, the coders who come up with the algorithms for the software. These people do not own the copyright. It is owned by your Microsoft, your Googles, and your ChatGPT or whatever, right? So do you need to register? You don't have to register. Your right is as of right, but in Malaysia, we provide for a provision that you can voluntarily notify and file an application for voluntary notification, and you get a certificate to show that you are the owner of that particular copyright. So when you want to show that you own rights in a particular material work, you should indicate to the world that that right is yours. Okay, so the categories of protected works, I mean, the common one is literary books. Books are literary works. When you write a book, it must be in a material form. And when it is already in a material form, copyright subsists in that material form, which is the book. Artistic work like drawings, you know, the Mona Lisa is a famous one. Musical works, I think most people won't be able to recognize tape cassette, you know, in my slide. And also film works are copyright, sound recording, broadcast, and derivative works. And the duration of protection is the author's life plus 50 years after death. And the performance for film sound recordings performance rights is 50 years after the publication, fixation, or performance. For broadcast, it's also 50 years. At one point, we wanted to extend this to 70 years, I believe. This was like about 5 years ago, but that didn't happen. Okay, next is confidential information. This is a right, this is also called trade secret sometimes. This is a right that subsists if your particular information is kept away from the public. It is common law right, and if a person breaches this right, you have a cause of action against that person. So it is not a registrable. You don't have a register where you can register your confidential information. It includes things like your business plans, you know, your client list, your contacts, your marketing strategies, your pricing when it comes to businesses. It's very important to make sure that you look after this confidential information, sales and distribution methods, you know, and your ideas when you want to conduct business. This comes in the form of like your presentation materials. You should always, when you come into business with a proposal with another person, you should try and get parties to execute a non-disclosure agreement so that, you know, the parties are assured that whatever is shared during that particular correspondence or communication should be kept in confidence, you know. And of course, the most famous trade secret is the Coca-Cola recipe or your KFC recipe, right? But it seems that the KFC recipe is no longer trade secret. You can see it, you Google it, you're going to be able to find it available in the public domain now. So if it's already in the public domain, you can't consider it as confidential information. Okay, so what do you need to protect yourself when it comes to confidential information? It has to be confidential. During your correspondence within your business team, if something is of confidence, you should clearly mark your correspondence as being private and confidential. And you should always indicate to your employees or your business team to not freely distribute this information in public without prior consent. And you can take action if somebody has used this information without your permission. So in Malaysia, there has been quite a few cases when it comes to confidential information. The Malaysian court recognizes that in Malaysia, we refer to the case of Coco Club, I think, where usually in cases of a competitor uses confirmation uses the information without permission, this is a breach of confidential information. Okay, so IP rights and potential infringements in relation to AI. Like Ms. Suriyia was saying just now, most AIs, they operate in the way that you would have to input data into the system. So like OpenAI, a lot of the data is available in the public domain, you know, and a lot of things in the public domain can be something, the IP rights for these things do belong to a lot of different parties, right? For example, books, a lot of books. I was looking at this talk by this scientist about how he wrote it. He talks about, he's a scientist that talks about quantum technology and these kind of things, and he has a book, and it seems that his book has been uploaded into the ChatGPT wholesale. So does that constitute copyright infringement? Because, you know, the AI will be referring to that book to come up with something that somebody else asked, you know, and would that constitute a substantial reproduction of that particular literary work, right? And a lot of information that is found online is a database that is contains information about private persons. So this may constitute an infringement of your personal data, right? And also, there's a lot of times where the AI uses brands to come up with its answer, kind of thing, right? And sometimes we have AI that uses a person's representation, the actors, the deepfakes, right? The deepfakes to pretend that it is that person. That will constitute a passing off. You are using the goodwill of a real person to pretend that it is somebody else lah. So these are some of the potential issues that we have in Malaysia when it comes to an infringement of an AI. So in relation to copyright infringement, like my Mr. Chu was saying, a lot of this is legislation based. In Malaysia, the legislation indicates that for you to be a person who is a qualified person under the Copyright Act, you would have to be a natural citizen of Malaysia, or a person who is a natural citizen of one of the burn countries, right? So in Malaysia, we do not yet have a case that talks about this. We don't have a case that talks about what happens if an AI comes up with a literary work or comes up with a painting, whether that particular use of the or production of the copyrighted work will constitute some form of copyright work. I mean, I don't think so. We will see after this, and you will find it quite interesting to see that we actually adopt the American position, where we don't recognize an AI as being a natural person. So Malaysia is AI is quite on vogue topic for the Ministry of Science, Technology and Innovation. We have a roadmap where we want to produce companies, and the government is looking into the existing statutes and legislations to see whether we are prepared to face this new change in technology when it comes to AI, right? And there's been a report made that it seems that Malaysia is quite ready in terms of readiness to face AI. We are quite high up within the Southeast Asian region. So what do they look for when they want to determine whether we are the AI readiness in Malaysia? So there are three pillars that they look at. The first is the government pillar. whether the Malaysian government has a strategy when it comes to facing AI readiness in Malaysia. It is quite safe to say that we are preparing ourselves to be ready to change the legislative landscape to be prepared for AI in Malaysia. I think we really have to look at the PDPA, we have to look at the Copyright Act and all the other legislation to decide how far we want to extend this idea of protection, whether it should go to generative AI or not, right? And whether the second pillar that they look at is the technology sector in Malaysia. Supposedly, Malaysia does have quite a substantial portion of technology sector where we do have some people in the workforce that are able to support the AI sector, business sector in Malaysia. And of course, the last is the data and in the infrastructure pillar, whether we have the necessary data infrastructure to make sure that the data that we use in the AI is safe. Okay, so the two main, I would say, legislative challenges that we face when it comes to AI is probably the copyright infringement and also data protection, because as I've mentioned already, a lot of the information used by the AI is through an input by the users, right? And it is only through this input that the AI is able to collate data to come up with a particular answer. So there is a risk that the collection and the processing of this data may infringe the Personal Data Protection Act in Malaysia. And it may be cases where people have inadvertently been releasing data that you are not supposed to into the public domain. Because in essence, AI strives on data, right? In order for it to learn, it has to have a lot of information for it to process before it can come out with that answer. So in Malaysia, we have the PDPA. This is the Malaysian government is quite serious in enforcing this PDPA in Malaysia, the Personal Data Protection Act. And we have the general principles when it comes to the PDPA. In essence, the main one is that you will need the consent of the data subject before you collect the personal data. The data users must inform the data subjects. If you take data from me, you must inform me that you are taking my data by a written notice. You must disclose you must not disclose the personal data for any other purpose than for the purpose that you have collected it. And you must take practical steps to protect the data that you have collated from the data subject. And when you keep it, you cannot keep it for a time longer than is necessary. And you must make sure that the personal data that you have collected is up to date, it is complete, and it must not be misleading. And the data subject must have access to their personal data to make sure that it is being used properly, in a sense. Okay, so what happens when this data may be uploaded onto an AI machine, right? So there may be instances in Malaysia where we have data leaks, right? We read a lot of this in the newspaper, and it is quite a concern because we share a lot of our data to a lot of parties in Malaysia. And we also notice that a lot of there have been some instances of breaches, but we do not know the extent of the same. So there may be instances where these data can have been obtained without our consent, and it breaches all the principles of the Data Protection Act. And this data is then uploaded onto the ChatGPT or one of those AI apps, for example. And this would definitely be a breach of the PDPA. So then the question would be whether would this can we take steps to remedy this breach of data protection? At the moment, I would say that it is not something that is provided for yet in the PDPA. So definitely legislation, the government has to come in to legislate on this issue. For copyright infringement, like I mentioned just now, it all boils down to the question of whether an author can be a non-human. You know, what would constitute a human vis-a-vis the Copyright Act? At the moment, it is the purpose of the Copyright Act is to enable the author, the person who comes out with the copyright, to protect his work from being from being used without his permission, right? So the idea of this copyright is always in relation to a person, right? Because you always have to look at whether the author is the songwriter, whether the author is the person who comes up with the music, whether the author is someone who is the photographer, right? So, I mean, it's safe to say from my reading of the Copyright Act, I don't think it covers an AI, because a qualified person is defined as an individual. I mean, a simple reading of this would mean that it is a human being or a citizen or permanent resident in Malaysia. And also, I would add that parties from the Berne Convention. So, for example, if you're an American citizen who has come up with copyright work, the protection under the Copyright Act in Malaysia will also subsist. If you are a person under the Berne Convention, and of it, you can either be the qualified person, can either be the person, or it can be a body corporate. So in our provisions, it is obvious that, and there's nothing that mentions AI in Malaysia for obvious reasons. AI is very new in the world today, although you can see that the way that it is becoming more sentient, right, is very fast, right? The technology is going in leaps and bounds, and it can be quite a challenge if we are not prepared in terms of governing AI in Malaysia. So my answer, I would say, AI cannot be a qualified person pursuant the Copyright Act in Malaysia. So if an AI draws a particular artistic work, I would safely argue that we cannot claim copyright over that artistic work. So there are two approaches that we notice at the moment. There is the UK approach and the US approach. And the UK approach is that there is a particular provision, amended provision in the UK Copyright Act, where it indicates that work generated by computer in circumstances such that there is no human author of the work, the author of a computer-generated work, the person by whom the original industry for the creation of the work undertaken, such provision could be invoked to identify AI developers as authors of AI-generated works. So it looks like they are going towards the route of allowing copyright protection even for AI. And the US approach again is this guy, I guess it's the same guy, right? This Thaler versus Perlmutter. In this case, he was trying to claim copyright protection for a work that was generated by AI. And the US courts decided that, you know, there's no provision in the US Acts that allows for an AI to be an author of a copyrighted work. So I think we are probably going to go through this same approach when it comes to AI in relation to copyright infringement, where we would probably have to legislate, we have to decide, do we want AI to be also included in the Copyright Act as a qualified person. That's going to be something fairly new, I guess, when it comes to intellectual property rights, because all this while the purpose of intellectual property protection is to protect the works of human beings, right? The Walt Disneys, the Stephen Kings. We are protecting these people when it comes to copyrighted works. An AI can come up. You can just type in ChatGPT and ask it to produce a book. Then does it mean that the ChatGPT is the author of that particular book? At the moment in Malaysia, I would say no. So, but it's interesting to see how we go with this. So, how about to IP practitioners? Lawyers such as myself and Ms. Suriyia. We had a bar recently. Actually, this was I see in the committee when we were talking about this. We are in the technology committee of the Bar Council, and we were talking about how there are some lawyers who are using AI or ChatGPT more precisely to draft letters, to come up with submissions, which personally I think should not be the case, because there are a lot of risks involved when we are going down this route. At the moment, I don't think that it is because we owe a duty to our clients to come up with that particular work. I don't think we should be subcontracting it to an AI, because at the moment, I do not think the AI is sufficiently intelligent enough, which is fairly ironic, to be able to appreciate the different ways of dealing with a legal problem in Malaysia. Okay, so there are some easy things that you can definitely use for the ChatGPT for, like drafting simple letters. If you really are the kind of person that can't be bothered, right, to draft a simple letter, you can use ChatGPT. It's fairly useful, I guess, right? But when it comes to more complicated legal issues, the Bar Council's position is that there are risks. We should be aware of risks when we are going down this route, and there are precautions when it comes to using an AI as a tool to assist our business. So when it comes to in other words, for simple things, yes, go ahead, use the ChatGPT or whatever to help you to draft a simple letter. I know some lawyers are doing this actively these days, but for more complicated matters, I don't think it is prudent to do so. We have to tread with caution when it comes to these kinds of issues. So the Bar Council of Malaysia position is very clear. I don't think we are prepared yet to allow for AI to be something that is going to replace the lawyers. But who knows, right? In another 5 or 8 years, things are moving fairly quickly. So it could be that we can be made redundant. So we'll all have to be software programmers later on. And so Malaysia is ready. There is a National Artificial Intelligence Roadmap. We are going to, like I mentioned just now, the government is actively looking into amending the legislation. The government is looking into making sure that we are ready to be prepared for this new incoming of technology in Malaysia. And of course, we want companies in Malaysia to be able to monetize from this industry. Perhaps it's going to be the next industrial revolution. We had one not so long ago, I guess, but this is probably going to be the next step, where the Malaysian economy can greatly benefit from being ready to prepare an infrastructure, be it in terms of the laws. We need to really change our laws to make sure that we are ready for the change in technology in Malaysia. We need to be able to have the physical infrastructure in terms of our servers, our internet, to be able to support this kind of business. And we should promote businesses in Malaysia to be ready to support this industry in Malaysia. So like I mentioned just now, it seems that Malaysia is quite ready when it comes to the AI roadmap in Malaysia in terms of readiness in the region. We are perhaps just behind Singapore and Thailand, maybe, right? So I guess we have to ensure that MOSTI, our Ministry of Science and Technology, continues with this momentum to ensure that we are prepared to receive this new technology in Malaysia, which is actually developing in leaps and bounds, like if you look at it. So basically, that's it for me. You can look at the Southeast Asia SME IPL website. We have a fact sheet of Malaysia in our website, and in the website, we provide an overview of all the IP rights we have in Malaysia. We give you an overview about how you can protect your IP rights in Malaysia, and it's just like a easy reference for businesses to look at when it comes to how you want to be ready when you come to the Southeast Asian region to prepare yourself to protect your IP rights. And we have our Mr. Benoit, who is one of the IP business advisors. You can contact him as well to get some free advice when it comes to protecting your IP in the Southeast Asian region. That's it for me. I think we have quite some time to answer some of the questions that the attendees have posted so far. Can I give this back to Mr. Chew?
Yes, thank you, Azrul. Wow, you've unpacked a lot. And I think some things are still in the luggage bag you haven't unpacked yet. but thank you very much. Having to survey the IP landscape traditionally and then trying to fit it into the AI categories is quite tough, as you have rightly pointed out, but thank you very much. Dear participants, I hope you've learned much from the two speakers. We will tackle a few questions that have come in along the way. I'll let Azrul take a rest.
Thanks.
He needs to gather some breath. And I posed a couple of questions to Suriyia. One is actually this thing about, for patent filing, we always have this concern about the word called prior art, right? So that, an invention is not patentable if there's prior art. So there's this question about how does this AI-generated works or AI-generated inputs, does it change the standards in terms of prior art? And also this other thing we say, like in our Patents Act, it says an idea or an invention is not patentable if it's obvious to someone reasonably skilled in the art. Does AI sort of, again, mess about with that concept because something may be more obvious now because you can actually ask ChatGPT, you get the answer. So it's really obvious, that kind of question. Yeah, Suriyia, Ken?
Yeah, sure. Yeah, so to answer that question, so basically it goes down to the basic as to what's prior art. So we need to know the basic understanding of prior art. So prior art consists of everything disclosed anywhere in the world, because as we know, patent is international. I mean, the concept, the standard of patents is international. So it revolves around everything disclosed anywhere in the world by written publication, oral disclosure, any form, so long as it's before the priority date of the application. So before the priority date, so which is the filing date, if the filing date that application claims priority, it goes back to the priority. So the question that was posed to me, so would AI be considered as prior art? So my answer is yes, it would be considered as prior art. It can be interpreted as prior art, so long as, the AI features contributes to technical character, where there's a technical character to be taken into account for assessment. So patentability criteria revolves around novelty, inventive step, industrial applicability. So in terms of inventive step, so what is inventive step? So basically, if we look at it's a problem solution approach. where it's a solution to solve a particular problem. So in order to assess inventive step in terms of AI, so AI couples, as I mentioned earlier, machine learning is integrated and forms AI, and AI forms computer implemented invention. So there's different levels to it. So then how do we perceive inventive step? I mean, if the answer is yes, as what I just mentioned, so how do we conclude whether AI is obvious to a posita? So posita meaning a person of ordinary skill in the art, where the posita has means and capacity for routine work and experimentation, say for example, to set parameters, in choosing training and validation sets. Yeah, so in terms of AI, the posita is required to evaluate complex mixed types of invention. Say for example, I mean, it can be so in applied AI fields, it may be a machine learning specialist, it could be an engineer. So basically, although it's machine learning, but in that machine learning, as I said, it's not just algorithm, it could be algorithm that is part of a module. A module could be a training module. So a training module may be coupled to another module. So long as there is a technical character in it, I mean, there's a technical character where there's different features. So different features that has got technical means in terms of machine language coupled to a device which forms a computer implemented invention. So that would be considered as having inventive step. But of course, having inventive step, it cannot be, as I said, the test is a problem solution approach where it cannot be obvious to a posita. Yeah. So basically that's how the test of inventive step, I mean, the same applies regardless whether it's AI as well as the traditional conventional invention. So the standard of test is still the same. So there need to be technical means, technical character, so long as it's not obvious to a posita. Yeah, where inventive step is gauged based on a combination of prior arts and not just a single prior art as opposed to novelty. Yeah, so I hope I answered the question.
Yeah, thanks, Suriyia. Yeah, I think you did. Again, we have to sort of understand maybe a bit more thinking about based on what you said, but I think it's saying that it still holds. Those concepts still holds, and even though it's an AI being involved, but maybe there's some nuances that have to be managed. So thank you. Maybe I'll ask this question because it was raised as one of the questions that came in. The CDPA of UK, this is something you mentioned, Azrul, about the fact that is it a precursor where the UK Act seems already to have recognized computer-generated works, right? As opposed to AI-generated content. And then as you pointed out in your slide just now, Azrul, it is, you said that the UK Act says there is no human author for that computer-generated work. So the one that used the computer will then be deemed to be the author. I think that's what the slide seemed to say. Correct me if I'm wrong, Azrul. So that seemed to be saying that. Then of course there are two different things. Because in your slide you mentioned, so the AI developer could then be seen as the human author, the deemed human author, right? But then there are two people at play, right? There's the AI developer, and then there's the user, which is called the one who prompts, the prompter. So also wondering whether is it the prompter or the AI developer that is seen to be the author for the copyright. We're not in the patent zone, we're in the copyright. Now, of course, Suriyia, if you have any comment on that point, please feel free to butt in as well. But Azrul, you got my question, right? I mean, just to clarify the point.
So the question is whether if it's a computer-generated work, what is the difference between the computer-generated work from AI-generated content, right?
Correct.
Yeah. So if I were to read this, I would say that the AI is the computer-generated work, right? The AI will be the one generating the work, right? So it can be interpreted that this provision would refer to the AI, because the AI is under this particular provision, right? And then the provision would apply where the author then shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. So the question is it the producer or is it the human author who came up with the AI? I would go with the latter lah, because you cannot say that a person, the user of a particular app, can be deemed the author, because then you would essentially be making the scope very large, right? Because even so, you are the one that came up with that particular work. Where did that work come from? The work came from data that has been obtained from the public domain, presumably. And this data has in itself separate, works. And how much of that work that you use to come up with your work? Is it a substantial reproduction of that data for you to come up with this particular work?
Yeah. Okay.
I wouldn't look it in as the prompter to be the one that can come up with this work.
Okay.
That would be my view. But
Fair
very
enough.
interesting question though.
Yeah. Thank
This
you.
one you really have to
Suriyia
use.
or even Martin, if you feel like jumping in, just please. Yeah.
I mean, yeah, I agree with Azrul, where AI generated content, computer generated works in accordance to the CDPA, how is it differentiated with AI generated content? Yeah, I agree, because AI generated content comes under the umbrella of computer generated work. So AI generated content, it focuses on algorithm, it focuses on source codes, it's linked to modules, it may be coupled to hardware. So it's still tied back to computer generated works at the end of the day. Yeah.
Thank you, Suriyia. I think Martin, you're going to say something?
Yeah, I was thinking about it. Of course, we are at the very beginning of a very complex legal discussion, and AI is really disrupting the way of thinking we had it before. And the main reason is that we try to identify a human factor, is or is there not a human factor? Because if there's a human factor, we need to protect this human. If there's no human factor, nobody needs to protect the machine. A car is damaged, okay, that's bad for the owner, but it's not bad for the machine because it has no feelings. So I don't think we have to, so that's the problem, is how much of a human is in an AI, and do this percentage of human which is in an AI needs a protection or not? I believe I don't think this is really our problem at the moment. I think our problem at the moment is we are still in the phase of where AI is developed. We are not yet there that our market is flooded with products from AI, and now we have to take. No, we are still at the phase where AI is built up. And we know that for building up AI, these foundation models are using data. And this is our first concern, because these are our data, these are human data, this is copyright work. So the first question is, the first one we have to protect are the humans. When these machines are using our human work, how can we protect the author? And there is different models, and saying this Japanese model is machines are not really using this work, they are just analyzing the work and then they extract some information, but they're not using the work itself. And then there's a European approach and saying, no, even machine reading and text reading is a use of the work, and the owner of the copyright should be protected. So that is something I think where we really relatively quick we will have an answer to it. It will go in the one or the other direction. So this is the infringement of existing IP rights by the machine. The second impact I see, practical impact for us, the professionals of intellectual properties, or the patent attorneys and so on, is I think what was mentioned about the impact on prior art. The impact on prior art and how patents will be in the future be evaluated. There's no doubt when something has been published, it doesn't matter by whom, a machine or whatever, something is out, is published, it doesn't matter by whom, we know that it doesn't matter by whom, but it is published, it's prior art, that's it. No, it doesn't matter what it is, a machine published, whoever, it's published, it's prior art. That's an easy question. However, I think there is an impact on non-obviousness, on inventiveness. I believe because a lot of the things we patent now, we patent because it requires a combination of more than, we have a doctrine in the European Union, when it requires more than 3 or 4 documents to combine to achieve the inventions, then we consider it non-obvious. I mean, the limit is basically 3 documents. When you need 20 documents to come to the inventions, then we say it's not, then it's inventive. When you need 2 or 3 documents to come to the inventions, then it is not invented. Then that's obvious. But these machines are combining millions of documents to come to the same achievement. So what I think is we have an impact on obviousness, and my prediction is that that in the future you need a much higher level of creativity and much higher inventiveness to beat the machines. Because when it can be, my guess is when it can be produced by a machine, it will not be patented. And so if you want to beat a machine, if you want to get a patent, despite all this AI working out there, you have to be really creative. And this is, I think, overall, I think we will see less patents in the future, and patents of a higher value. Really, only the really creative things which cannot be combined by existing knowledge. Okay, then is here, and okay, that's my intervention for a moment. Yeah.
That's a scary prediction, Martin. The patents going down. Yeah. Okay. Maybe I'll just tackle the last question, which is a practical question. I know we don't have much time left. I hope you don't mind me this, because finally the practical question is, what should companies look out for when dealing with AI? I myself have received queries from clients. How can I safely use AI in my company? And I kind of say that there is no 100% safety. All right, it's how you apply risk management when you're using AI. But I just wonder whether Azrul or Suriyia or Martin has any simple tips on companies deciding to use AI. And of course, it's almost like if you don't, you're going to lose out, Yeah. Yes, Martin.
Yeah, I think there's no need to invent the wheel. Many big companies already have guidelines, and I can tell you particularly the European Commission has guidelines how we are using ourselves AI. We are using it because it is so useful. When you have a long conference like this one here, for instance, if I would have an AI tool which is already existing, listening in, it would give me now afterwards a summary. Or when we have when we have to prepare briefings, we have an AI tool now in the Commission, which is from a subset of complicated and technical documents. It makes a policy briefing for decision makers. So we are already using in the Commission the AI, and we have a set of guidelines. And my recommendation, if you are planning to set up a guidelines for your company, look on the existing one and then make a nice summary, adapt it to your needs, and but you don't have to invent the wheel again. There are guidelines out there.
I mean, just to add a bit about on that, I mean, I believe that even in Malaysia, I mean, many companies are AI based because the process workflow in terms of different areas of businesses, I mean, AI is really helpful. So again, yeah, it's back to the company itself as to the SOP that they need to practice. But it's something that, I mean, everybody should actually look into because it really helps. I mean, it's really efficient in various areas.
Thank you. Azrul, any parting words?
It's definitely a very useful tool. It can help you use properly, as all things in life. If you use it properly, it will benefit you. If you use it with the wrong reasons, it will be bad for you, in a sense. So use with caution.
Yeah, thank you very much. Yeah, so I just have to stop here now, and I just want to thank once again the speakers for being so clear and helpful in their iterations about AI from their respective fields. I'd like to hand over now to Martin for some closing remarks before I hand over back after that to Loishini. Thank you very much.
I can end my closing my closing remarks how I have ended my opening remarks. I want to thank you again very much for the EuroCham for organizing it together with the SME Helpdesk. I think it's exactly the kind of organizers we should have, because you are close to the real questions of the real business of real people in the region, and you have a feeling, and as we saw today, you are addressing questions which are really necessary for business to have an answer. For instance, is it a risk to, should I use AI? Is it a risk? Are there guidelines? How do I do when I confront an AI generated work, and do I have to, if I have a client using AI, how do I deal it? So thank you very much again, also on behalf of the European Commission, for your wonderful seminar, very helpful. And again, I would say AI is, we do not really have a choice if we use AI or not. It's just already there, and when you don't use it within a short period, you will be out of business. So we have no choice. And thank you. And I would encourage EuroCham again, not to make it just a one-stop seminar. Maybe we can have it on a regular basis, because the development is very fast, and we would be happy, and I would be very happy to be again invited again and follow the development. Following development, not on a theoretical side, but actually on the practical side, which only you can offer. So thank you very much also for inviting us. Thank you very much.
Thank you, everyone, for your participation. We extend our gratitude to all the participants who joined this webinar until the end. Also, to the Southeast Asia IP SME Helpdesk, EuroCham Malaysia, and the respected guest speaker for ensuring the success of this webinar event. To our participants, Southeast Asia IP SME Helpdesk offers various free services, including an inquiry helpline, website and newsletter, training and live webinars, IP business tools, and publications. Please do not hesitate to reach out to us for further inquiries about these services. We also want to hear any feedback from you. Please scan the QR code from the screen. Once again, thank you for joining us today, and we look forward to seeing you next time. Thank you.